Welcome to the Supreme Grammar Podcast, where you'll learn to write like a Supreme Court Justice, with me, Jill Barton. Today, our AI hosts discuss how to write every part of an appellate brief, from the issues presented through the conclusion. The best approach? Take it step by step. Let's dive in.
Okay, so law school, right?
Right.
It can feel like you're constantly just treading water.
Oh, yeah.
But today, we're throwing you a life preserver.
Okay.
We are diving deep into appellate briefs.
Oh, exciting.
And trust me, this is going to make you feel way more confident about the whole thing. We've got excerpts from the handbook for the new legal writer, which is basically like your cheat sheet
Absolutely.
to surviving this process.
Yeah, and what's really great about this handbook is that it breaks down this really daunting task of writing an appellate brief into manageable steps.
Yes.
And it's not about reinventing the wheel.
Right.
It's about using a proven system to your advantage.
Totally. And let's be honest. The idea of arguing your case to a higher court, maybe even like the Supreme Court,
oh, wow.
with a writ of certiorari.
Yes.
I mean, that's both terrifying and kind of like the whole reason we went to law school.
It is. It's like the legal equivalent of the big leagues, right?
Totally.
And this handbook is your playbook.
It is your playbook. Okay, so first things first, appellate courts.
Yes.
They're not messing around when it comes to format.
No, they are not.
They have totally different rules than trial courts.
Yes, completely different.
And if you don't follow them,
Oh.
gone, case dismissed.
Yeah. The handbook makes this very, very clear.
It does.
And it even gives you a lifeline. You can find templates online.
Oh my God. But okay, let's talk about the structure of the brief itself.
Okay.
So I've got the cover, the table of contents, table of authorities.
Yes.
All very official sounding.
Very important.
Right.
And these are all essential elements that signal to the court that you are taking this seriously, that you are a professional.
Yes.
It's about building credibility from the very first page.
Yeah. So it's like you're not just some random person yelling objection in a courtroom. You're a lawyer who knows their stuff.
You've got this.
Yes. Okay. Now, before you even get to the heart of your argument, you need to understand this thing called the standard of review.
The standard of review.
Okay, full disclosure. When I first encountered this term, my eyes glazed over a little bit.
I feel you.
But the handbook actually makes it make sense.
It does. It's actually fascinating.
Okay.
What's fascinating about the standard of review is that it essentially tells you how much leeway the higher court has to question the lower court's decision.
Okay.
So it's like, are they going to scrutinize every little detail?
Okay.
Or are they going to give the lower court the benefit of the doubt?
Oh, that's interesting.
Yeah. And to make it even trickier,
oh no,
there are different standards for questions of law versus questions of fact.
Oh, wow.
So some appeals are automatically uphill battles.
Right.
Depending on what you're arguing.
That makes sense. That's where the strategic brilliance of the handbook comes in.
Yes.
It tells you to find cases that apply the standard in your favor.
Yes.
So you're basically building your argument on a foundation of precedent.
Absolutely.
That supports your position.
Yes. You're shaping the narrative by highlighting cases that have already set a precedent for how the court should view your type of appeal.
Okay. So you're not just blindly throwing cases at the wall and hoping something sticks.
No.
You're choosing your ammo carefully.
Exactly.
Okay, now let's talk about the issue presented.
Okay.
This is where you really grab the court's attention.
This is it. This is your first opportunity to persuade the court.
Okay.
The handbook calls it a did-when structure.
Okay.
Short, punchy, and loaded with legal weight.
I like it.
Yeah.
Can you give us an example?
Of course.
Because I'm picturing something very dramatic, like a courtroom scene from a movie.
Okay, so imagine your case involves a denied motion to suppress evidence. Okay, instead of saying, did the court err in denying the motion?
Right.
You would say, did the trial court err when it denied the motion to suppress despite clear evidence of an illegal search?
Whoa. Okay, I felt that.
Yeah.
You added context to motion. And the issue suddenly feels way more significant.
Exactly. And the handbook recommends writing a separate issue presented for each major argument in your case.
Got it.
So you're essentially breaking down your overall argument into these mini persuasive punches.
Okay, so it's like a 1-2 punch combo.
Yes.
Except maybe like a 5-punch combo,
Exactly.
depending on how many issues you're raising.
Precisely.
Yeah.
It's a brilliant way to keep the court engaged and to make sure they understand the core of your argument right from the start.
Love it. Okay, next up is the facts section,
Okay.
which I'll admit sounds kind of boring.
I know. It sounds a little dry, but don't let the name fool you.
Okay.
This is where you weave a narrative that connects with the judges on an emotional level.
Okay.
It's not just a dry recitation of what happened.
Yeah.
It's your chance to tell a compelling story that makes the court want to rule in your favor.
So how do we make a list of facts into a captivating story?
Well, the handbook emphasizes the power of persuasive subheadings.
Ooh.
Think about it. Shower's filed suit
Yeah.
is a lot less impactful than Shower's desperate attempt for justice.
Oh, wow, that's genius. Same facts,
Yeah.
but one just pulls you in.
Exactly. And of course, you absolutely need citations to the record on appeal
Right.
for every single fact you present.
Okay.
The handbook hammers this home repeatedly because it's about credibility.
Yes.
If you can't back up your facts,
Right.
your entire argument falls apart.
Of course. So you're not just telling a good story,
Yes.
you're backing it up
Yes.
with hard evidence.
Exactly. And
Yeah.
that's what makes the facts section so persuasive. You're appealing to both the heart and the head.
Okay. So we've got our persuasive headings,
Yes.
our rock-solid citations, but this is a legal document.
Right?
How do we actually structure this like a story?
Well, the handbook suggests a chronological approach.
Okay.
But with a twist, you arrange the facts to highlight your client's perspective
Right.
and subtly undermine the opposing side's argument.
Oh, sneaky. I like it.
Oh,
So it's like a legal choose-your-own-adventure,
I love that.
but you're guiding the court towards the ending you want.
That's a great way to put it. You're crafting a narrative that leads the court to the inescapable conclusion that your client deserves to win.
Okay, now let's talk about the summary of argument.
Okay.
This is your one shot to really sell your case, right?
It's your legal elevator pitch. You have 1 page, maybe even less, to make your case and leave a lasting impression. The handbook calls it your opening statement for a reason.
No pressure. But seriously, this sounds incredibly important.
It is.
The handbook must have some killer advice for this section.
It does. And it includes a fantastic example
Ooh.
from a real brief.
Okay.
In the case of Bowers v. Hardwick,
I've heard of that one.
a landmark case about privacy rights,
Right.
the stakes were incredibly high. And the summary of argument in that brief perfectly captured the drama and the core values at play.
Okay. Stop. I need to hear more about this. Like, what was so amazing about this specific example?
Well, it was brilliant because it didn't just summarize the legal arguments.
Well,
It painted a vivid picture of the injustice at hand.
yeah.
It talked about the sanctity of the home,
Wow.
the importance of individual freedom,
Right.
and the overreach of government power.
Okay, that's powerful. It sounds like it went beyond just the law
Yes,
and tapped into these universal themes that anyone can relate to.
exactly. And that's what makes a great summary of argument so effective. It connects with the reader on an emotional level while still maintaining legal rigor and clarity.
So it's about persuasion,
Yes.
but not in a manipulative way.
Right.
It's about presenting your case with conviction
Yes.
and highlighting the human element within the legal framework.
You got it. And the handbook emphasizes that your summary of argument should weave together your theme, your strongest points, and why ultimately you deserve to win.
Okay, so it's like the climax of a good movie.
Yes.
Everything builds up to this moment where you make your final plea
Yeah,
and hope the court sides with you.
exactly. And if you've done your job right in the previous sections, the summary of argument will feel like the natural and inevitable conclusion to your entire case.
This is all making so much more sense now. The handbook is really breaking down this seemingly insurmountable task into manageable steps.
It's like a roadmap to appellate brief writing success.
But hold on.
Yes.
We're not done yet.
Oh, no.
There's still so much more to cover.
Okay.
Like those seemingly insignificant but oh so important details that can make or break your brief.
Things like transitions, headings, and umbrellas.
Ooh, umbrellas.
Yes, they might seem boring,
Okay.
but trust me, they're the secret sauce to a cohesive and persuasive argument.
And we can't forget about those sections that make even seasoned law students groan.
Yes, I know what you're talking about.
Table of contents and table of authority.
I know. They're
Yeah.
so important. Don't
Yeah.
underestimate their power. They might feel tedious, but they're crucial for showcasing your organization, attention to detail, and professionalism.
It's like showing up for a job interview in a wrinkled suit
Oh, yeah.
versus a sharp-tailored one.
I see what you're saying.
Both might get you the job,
Right.
but one definitely makes a better first impression.
Absolutely. A well-organized table of contents makes it easy for the court to navigate your brief and find the information they need quickly.
And a comprehensive table of authorities demonstrates the depth of your research.
Yes.
And ensures that you're citing everything correctly.
It's all about the details. No judge wants to waste time tracking down a missing citation.
So true. It's about respecting the court's time.
Yes.
And showing that you've done your due diligence.
Absolutely. Okay, so we've covered the structural elements.
Yes.
But let's get back to the heart of the brief. What about those crucial cases
Yes.
we cite to support our arguments?
Choosing the right case law.
Ah, yes. This is like assembling a crack legal team to back you up. It's not just about finding cases that vaguely relate to your topic.
Okay.
It's about selecting cases that strengthen your specific arguments.
Yeah.
And have favorable outcomes.
So it's like a legal game of chess,
I love that analogy.
where each case you cite is a strategic move.
You got it. And the handbook gives some brilliant advice on how to select your cases strategically.
Okay.
It suggests looking for cases that are procedurally similar to yours,
Okay.
so the court can easily see how the precedent applies.
So it's like finding a case where the judge was basically faced with the same dilemma
Exactly.
and ruled in a way that supports your argument.
Precisely. You're building a chain of legal reasoning that leads the court to the conclusion you want.
So we're not just randomly citing cases to sound smart.
No.
We're carefully curating a legal narrative
Yes,
that supports our client's position.
that's the key.
Yeah.
And the handbook even suggests organizing your case law in a way that creates a narrative arc.
Oh, interesting.
Start with broad foundational cases that establish general legal principles. Then narrow your focus with cases that are increasingly similar to yours,
Got it.
culminating in a case that's almost a mirror image of your own.
Oh, that's clever. It's like building a legal pyramid,
I like it.
with each case acting as a building block, leading up to the undeniable conclusion that your interpretation of the law is correct.
Exactly. And by the time the court reaches your strongest case, they'll already be nodding their heads in agreement.
Okay. Now let's circle back to something we talked about earlier,
Yes.
setting aside your brief before revising it.
So important.
The handbook emphasizes this point multiple times,
It does.
and I'm starting to see why it's so crucial.
Because it's tempting to just power through and submit your brief as soon as you think you're done.
Right.
But trust me, that's a recipe for disaster.
I can imagine. When you've been staring at the same document for hours, you become blind to your own errors and weak spots in your argument.
Totally. Taking a break, even for a few hours, allows you to approach your work with fresh eyes and catch those pesky typos, grammatical errors, and inconsistencies in your reasoning.
It's like cleaning your glasses.
Yes.
Suddenly everything is clearer.
Exactly. And speaking of clarity, let's revisit the summary of argument. We talked about the amazing example from Bowers v. Hardwick,
Yes.
but I think it's worth breaking down WHY. It was so effective.
Yes. It clearly made a huge impression on you, and I'm dying to know what made it so special.
Well, the first paragraph was like a hook.
Okay.
It set the stage by highlighting the stark contrast between the two sides and emphasizing the reasonableness of the respondent's position.
It's like the opening scene of a movie, setting the mood and introducing the main conflict.
Exactly. And then the second paragraph really dug into the core values at stake in the case.
Right.
It wasn't just about legal technicalities. It was about the sanctity and privacy of the home.
So it appealed to both logic, A&D emotion.
Precisely. And finally, the third paragraph clearly laid out the relief requested, leaving no room for ambiguity.
So it was like, here's what we want, and here's why we deserve it.
Exactly. It was powerful, persuasive, and memorable. And the best part, this structure, setting the stage, highlighting the values, and clearly stating the relief,
Right.
can be applied to any summary of argument, no matter the topic.
That's incredibly helpful. A template for crafting a winning closing argument.
You could say that. And remember, your summary of argument is often the last thing the judges read before making their decision.
Right.
So you want to leave them with a lasting impression.
So it's like the mic drop moment of your entire brief.
Exactly. And if you've followed the handbook's advice, your summary of argument will be the culmination of a carefully crafted legal masterpiece.
Okay, this is all starting to feel a lot less overwhelming.
Good.
The handbook is really breaking down this daunting task into manageable steps.
It is. And it's filled with even more practical advice and real-world examples that can help you take your brief writing to the next level.
But before we get too carried away, there's one more crucial piece of the puzzle we need to discuss.
Okay.
The conclusion. It's like the final bow after a Broadway performance.
Exactly. It's your last chance to drive home your key points and leave a lasting impression on the court. You want to reiterate the relief you're seeking
Right.
and remind the judges why they should rule in your favor.
So it's like, we've presented our case, and now we're asking you to do the right thing.
Precisely. It's a powerful way to end your brief on a high note and leave the court with a clear understanding of what you want them to do.
I'm curious to hear what stood out to you as the most valuable takeaway from the handbook.
Honestly, there are so many gems in this handbook. It's hard to pick just one.
Right.
But I think what resonated with me the most is the emphasis on crafting a cohesive narrative
Okay.
throughout the entire brief.
You mean like it's not enough to just have strong individual sections?
Right.
They all need to work together?
Yes. It's like building a house. You need a strong foundation, sturdy walls, and a beautiful roof.
Right.
But you also need like the beams and the nails to hold it all together.
So it's not just about legal arguments.
Right.
It's about creating an experience for the judges.
Yes.
Taking them on a journey that leads them to the inevitable conclusion that your client deserves to win.
Precisely. And the handbook provides so many practical tools for achieving that cohesion. From the big picture stuff like theme and narrative arc, down to the nitty-gritty details like transitions and headings.
Speaking of those nitty-gritty details, I have a confession.
Okay.
I used to think the table of contents was just a formality,
Mm-hmm.
something you just slap together at the end.
Yeah.
But the handbook actually opened my eyes to its strategic value.
I know, right? It's not just a roadmap for the judges.
Yeah.
It's a roadmap for you as the writer.
By looking at my table of contents,
Right.
I can see if my argument is flowing smoothly, if my headings are persuasive,
Mm-hmm.
if I've covered all the necessary points. It's like a checklist for ensuring my brief is on track.
Exactly. And if you're struggling to create a cohesive narrative,
Right.
the table of contents can reveal those gaps in your logic or areas where your argument needs more support.
Okay, so the table of contents is more important than I realized.
And just like a good movie director, you want to control the narrative from beginning to end, leaving the court with a clear understanding of why your client deserves to win.
And who knows, maybe one day you'll be arguing a case before the Supreme Court,
Oh, wow.
armed with the wisdom of the handbook and the confidence to win.
That's the dream. Until then,
Yes.
happy writing, fellow legal eagles.
An appellate brief can feel overwhelming, but breaking it into steps and writing each part on its own makes the task manageable. You'll find more guidance in Chapter 33 of the Handbook for the New Legal Writer, including a full example on page 287. And always remember, you can be a great legal writer.